My hands wouldn't stop shaking when I read the text. It was a Tuesday morning in October. I'd just come in from the garage. I'd been out there since 6, the way I always am, tinkering with the old Craftsman table saw I'd been meaning to restore for 2 years. My coffee was still hot. The dog was at my feet. It was the kind of morning that feels like nothing bad could ever happen in it. Then my phone buzzed on the kitchen counter. Call me before you do anything today. Do not sign anything. This is urgent. It was from my attorney. 43 years I'd known this man. He'd drafted my will when my wife and I bought our first house in Dayton. He'd helped me close out my business when I retired. He wasn't someone who used the word urgent lightly. He wasn't someone who texted at all, usually. I called him back before I even sat down. Norman, he said. That's me, Norman Calloway, 67 years old, retired civil engineer, father of 2. Are you alone? Something about the way he asked that made the hair on my arms stand up. I told him yes. My son had his own place across town. My daughter lived 40 minutes away in a suburb called Fairfield. My wife, Helen, had been gone 3 years now. Breast cancer. It still catches me off guard sometimes, reaching for the phone to tell her something and remembering she's not there. Are you sitting down? He asked. Just tell me, I said. He told me. I had to set my coffee mug down because I genuinely thought I might drop it. I should back up and explain something about my financial situation because it matters. When I retired at 63, I wasn't wealthy by any dramatic standard, but I was comfortable. Helen and I had been careful our whole lives. We paid off the house in 2009. I had a pension from 31 years with the county, a 401A, that had done reasonably well, and a brokerage account I'd built slowly over the years by not doing anything stupid with it. When Helen passed, her life insurance added another layer. All told, I had somewhere around $800,000 in assets, the house included, and I was living well within my means. I didn't talk about money with my children. That wasn't how Helen and I raised them. We gave them both good educations, helped them with down payments on their first homes, showed up when they needed us. I didn't think any of that needed to come with a dollar amount attached. My son, Theo, he's 39, works in IT, lives a quiet life, never seemed particularly interested in what I had. He called every Sunday. He drove out to help me re-roof the back porch last summer without being asked. He was just a good person. I should say. He is a good person. My daughter was another matter, though I didn't see it clearly until it was almost too late. She'd always been the driven one. Competitive in a way that was exciting when she was young, and started to feel like something else when she got older. She married a man named, well, I'll call him my son-in-law, about 12 years ago. He sold commercial real estate. He was the kind of man who talked about money the way other men talked about sports, constantly, enthusiastically, as if the score mattered more than the game itself. I'd never particularly warmed to him. Helen was more charitable. She always said he just didn't know any other language. After Helen died, my daughter started calling more often. I appreciated it at first. Grief is lonely. She'd stop by on Saturday mornings with coffee and sit at the kitchen table and ask me questions. How was I sleeping? Was I eating right? Did I want help organizing Helen's things? I thought she was being a good daughter. I thought I was lucky. I didn't notice when the questions changed. Dad, are you keeping up with your accounts? It's a lot to manage on your own. Have you thought about whether the house is too much? A smaller place might be easier. You know, there are financial advisors who specialize in helping people in your situation. People in your situation. I remember that phrase bothering me, but I brushed it off. I was 67, not 107. I was still driving, still working on projects, still had all my faculties. But I didn't say any of that. I just nodded and drank my coffee and told her I was fine. Then, about 4 months ago, she asked me to sign something. She brought it over on a Sunday. Said it was a convenience document, something her husband had mentioned, could simplify my financial management, a durable power of attorney. She'd already had it prepared. She set it on the table in front of me while I was still in my reading glasses and slid a pen next to it. It just means if something ever happened to you, I could handle things without it becoming a legal mess, she said. I didn't sign it that day. I said I wanted to read it first, which seemed to catch her off guard. She smiled and said, of course, take your time, and left it with me. I put it in the drawer under the kitchen counter and didn't look at it again for a week. That was apparently the wrong answer. What my attorney told me on that Tuesday morning was this. 3 weeks earlier, my daughter and son-in-law had met with a different lawyer, not mine, not anyone I knew, and had begun exploring a petition for guardianship. Not power of attorney, guardianship. The kind you pursue when someone is declared legally incapacitated. The kind that gives the guardian full control over every financial and medical decision. The kind that, in practical terms, means the person it's filed against stops being a person with legal rights and becomes a ward. They were building a case that I was mentally unfit to manage my own affairs. My attorney had found out through a colleague, a small world, the legal community in a mid-sized Ohio city, who'd flagged it as a conflict situation and reached out quietly. The petition hadn't been filed yet, but it was being prepared. I sat in my kitchen for a long moment after he finished talking. The dog had fallen asleep at my feet. The coffee had gone cold. Outside the window, a neighbor was mowing his lawn, and the sound of it felt completely unreal, like I was watching a movie of a normal Tuesday morning from somewhere very far away. "What does this mean?" I finally said. "It means they're going to argue you can't manage your own finances," he said. "And if a court agrees, they become your legal guardians. They control your accounts, your investments, your medical decisions. Everything." "On what basis?" My voice came out steadier than I felt. I'm perfectly. I know," he said. "But that's what we have to prove. And Norman, I need you to understand something. People who pursue this kind of action don't always need strong evidence. They need the right paperwork and the right timing. Don't sign anything your daughter brings you. Don't make any large transactions. Don't do anything that could be framed as impulsive or confused. And come see me tomorrow." After I hung up, I sat there for a long time. I thought about that Sunday dinner she'd had me over for 2 weeks ago, the one where she'd seemed so warm and attentive, asking about my health, asking if I'd had any memory issues, any confusion. I'd thought she was being caring. I understood now she was taking notes. My attorney's name was Maxwell. I'll just call him my attorney, because that's how I've always thought of him. 43 years. He'd gone to law school at Ohio State. His office still had the same dark wood paneling it had in 1982, and he'd never seemed to consider redecorating. When I sat across from him the next morning, he laid it out plainly. "The basis they're building is financial incompetence," he said. "That unsigned power of attorney document, the fact that you didn't sign it, frankly, is something they may try to use. They could argue you're too confused to understand what you were being offered." "That's backwards," I said. "Yes, that's how these things work." He explained that a guardianship petition in Ohio requires a medical evaluation, a court hearing, and a finding that the person cannot manage their own affairs. It wasn't a slam dunk for my daughter, but it wasn't impossible either. With the right doctor and the right framing, an elderly widower living alone who hesitated to sign a document that would help him could be made to look uncertain, confused, a risk to himself. "They've hired someone to evaluate your behavior over the last several months," he said carefully. "What does that mean?" "It means someone has been observing. Possibly asking questions to your neighbors, your doctor's office, building a picture." I thought about the neighbor down the street who'd asked me, a few months back, about whether I was still driving okay. I'd thought she was just making conversation. "So what do we do?" I asked. My attorney leaned forward. "We prove you're not only competent, we prove you're sharp. We document everything. Cognitive evaluation from your own physician. Bank records showing consistent, rational management. And we need to understand how far along their petition is." Then he told me the other piece. "There's something else," he said. "Someone reached out to me directly. 2 days ago." He slid a piece of paper across the desk. It was a printout of an email, short, 3 sentences, from an address I didn't recognize at first. Then I did. It was my granddaughter. My granddaughter was 20 years old and a sophomore at the University of Cincinnati. She was studying pre-law. She was the kind of person who read the terms and conditions before clicking agree and argued with her friends about constitutional amendments at dinner. I loved her the way you love someone who reminds you of your best self. She'd been living with her parents, my daughter's house, until she went to college. She'd been home for fall break, and apparently she'd overheard something she wasn't supposed to. My attorney had already spoken to her by phone. She'd heard her parents, her own parents, discussing the guardianship plan in their home office with the door cracked open. She'd heard her mother say, and I'm paraphrasing what my attorney relayed to me, "The longer we wait, the more he might spend down. We need control of it while there's still something to control." My granddaughter hadn't slept that night. In the morning, she'd looked up my attorney's name from an old document she found in a box her mother kept, and she'd sent him that email. She'd also done something else. She'd taken out her phone while her parents were still talking and recorded 11 minutes of the conversation. When my attorney played me the audio on his computer, this was later that same week, after he'd verified it with her, I had to get up and walk to the window. I stood there for a minute with my back to the room. I heard my daughter's voice say my name. I heard her husband say, "He's not going to contest it if we frame it right. He trusts her too much." I heard my daughter laugh a little, not a warm laugh, and say, "That's the whole point." I'm a man who grew up in a household where you didn't show people when they'd hurt you. My father's generation. You held it in, you worked through it, you kept going. I've tried to live that way my whole life. But standing at that window in my attorney's office, I felt something crack open in my chest that I wasn't sure I'd be able to close again. My daughter, the girl I'd taught to ride a bike in our driveway on Maple Street, the one I'd stayed up all night with when she had scarlet fever at age 7, the one I'd walked down the aisle and handed to a man I'd shaken hands with, and tried, genuinely tried, to love because she loved him. She had looked at me and seen an estate to be managed. Not a father, not a person. A number in a column that needed to be secured before it could disappear. I took a breath. I turned around. "Tell me what we need to do," I said. The next 6 weeks were the quietest kind of war. I didn't let on to my daughter that I knew anything. She called twice a week. I answered. I asked about her husband, about my granddaughter, about the house. I said I'd been thinking about that document she'd left and that maybe she was right, maybe it made sense. I hated every word of it. But my attorney had told me not to tip my hand, and so I didn't. Meanwhile, we built our case. I had a full cognitive evaluation done by my own physician, a neurologist my doctor referred me to, who ran every test they had. Vocabulary, spatial reasoning, processing speed. I came back in the 91st percentile for my age group. My physician signed a detailed letter. I had 3 years of bank records showing consistent, methodical management, no impulsive purchases, no large unexplained transfers, no signs of the kind of financial disarray the petition would need to claim. My attorney contacted a forensic accountant who reviewed my records and wrote his own statement. We had neighbors, 3 of them, who wrote letters about their regular interactions with me, my lucidity, my independence, my competence, and we had the recording. My attorney had consulted with a colleague about Ohio's wiretapping laws. Because my granddaughter had been physically present in the home, and Ohio is a one-party consent state, the recording was legal. It was admissible. It was 11 minutes of my daughter and son-in-law discussing how to have me legally declared incompetent, so they could access my assets before I gave them away, or spent them down. The petition was filed in the second week of November. We were ready. The hearing was held on a Thursday morning in a county courthouse downtown. I wore the gray suit I'd bought for Helen's sister's funeral years ago. It still fit. I sat next to my attorney at a table on the right side of the room, and I didn't look at my daughter until I had to. She and her husband sat across the aisle. They had an attorney, too, younger than mine, sharp-looking, in a charcoal jacket. When she walked into the courtroom and saw me sitting there calm and prepared, something moved across her face. Not guilt. Something harder to name. Recalculation, maybe. Their attorney presented the narrative. A grieving widower, living alone, showing signs of withdrawal and confusion, who had declined to sign a reasonable document intended to help him, suggesting he either didn't understand it or was being influenced by someone else. My attorney stood up. He entered the neurologist's evaluation, the bank records, the 3 neighbor letters, the forensic accountant's statement, and then, with the judge's permission, he played the recording. 11 minutes. I watched the judge's face while it played. He was a man about my age, maybe a few years older. He had the kind of expression that gives nothing away. But I watched his jaw tighten at a certain point, the moment where my son-in-law said, "We need control of it while there's still something to control." A small tightening, almost imperceptible. Almost. My daughter's attorney objected twice. Both objections were overruled. When the recording finished, the courtroom was quiet for a moment that felt much longer than it was. The judge denied the petition. Not just denied, he questioned from the bench whether the filing had been made in good faith. He used the words troubling evidence of improper motive. He noted that the subject of the petition, me, Norman Calloway, had demonstrated extensive and documented competence, and that the opposing evidence was, in his words, absent. He also noted that the matter might warrant referral to the state bar and potentially to Elder Abuse Protection Services for review. My daughter left the courtroom without looking at me. I've thought a lot about what I wanted to feel after that day. I expected relief. I expected anger. What I actually felt, mostly, was tired. The particular tiredness that comes not from exertion, but from discovering that something you believed in wasn't real. I drove home from the courthouse and sat in the kitchen for a while. The dog climbed up next to me on the couch, which I don't usually allow. That day I let him. I called Theo that evening. I told him everything, not in the controlled, tactical way I'd been holding it for 6 weeks, but all of it, the whole unraveling, from the first text to the courtroom. He didn't say much for a long time. When he finally spoke, his voice was rough. "Dad," he said. "I'm so sorry." "You didn't do anything," I said. "I know. I'm sorry it happened to you." That was it. No elaborate speech. Just that. I needed it more than I would have thought. In the weeks after the hearing, I went back to my attorney and we updated my estate plan entirely. The will, the trust documents, everything. My granddaughter, she had driven 3 hours from Cincinnati without telling her parents, shown up on my doorstep 2 days after the hearing with a gas station coffee and red eyes, was named a primary beneficiary. A significant portion was directed to a scholarship fund I set up through the County Community Foundation in Helen's name. The rest would go to a veterans organization I'd volunteered with for years. My daughter received nothing. I didn't do it out of bitterness. I want to be honest about that. I'm not sure I have the capacity for the kind of sustained bitterness that people sometimes carry. What I did was make a clear-eyed decision about who in my life had chosen something larger than money when it counted. My granddaughter had risked her relationship with her parents, her home, her safety net, her family peace, to send a 3-sentence email to an old lawyer she'd never met because she thought it was right. That told me everything I needed to know about her character. I wrote a letter to my daughter and had it delivered through my attorney. I kept it short. I told her I was aware of what she'd done and why. I told her I didn't plan to pursue any legal action against her beyond what had already occurred. I told her that if she ever wanted to talk, not about money, not about the estate, just to talk, as a father and a daughter, she could reach out. And then I told her something I'd been turning over in my mind since I'd stood at that window in my attorney's office and listened to her voice on a recording, that the worst part wasn't the plan itself. The worst part was realizing how long she'd been looking at me without seeing me. She didn't respond. My granddaughter drives out most weekends now. She brings her casebooks and studies at the kitchen table while I work in the garage. Sometimes we eat lunch together. Sometimes we just exist in the same space without needing to fill it with words. She has her grandmother's laugh. I've noticed that more lately, the same sudden quality to it, surprised out of her, real. It catches me off guard sometimes in the best way. Last Saturday she looked up from her reading and said, "Grandpa, do you ever think about what would have happened if you'd just signed that paper?" I thought about it for a moment. "I think about what would have happened if you hadn't been home for fall break," I said. She nodded. She went back to her book. I went back to the table saw. There are things you can't recover. I know that now in ways I didn't at 60. Illusions about the people you love. A certain innocence about what family means. The version of my daughter I thought I had. Those things don't come back. But there are things that hold. A granddaughter who drove 3 hours on a Tuesday. A son who said, "I'm sorry it happened to you," and meant it in exactly the right way. A dog who doesn't ask for anything except to sit close. The sound of a table saw in a cold garage on a Saturday morning. The smell of sawdust and machine oil. The satisfaction of making something true and level and straight. I don't know what my daughter sees when she thinks of me now. I don't know if she's found a way to make peace with what she did, or if she's found a way to believe I was the one who wronged her, or if she just doesn't think about it at all. I've stopped trying to understand it. What I know is this. The people who tried to reduce me to a balance sheet found out I was something harder to erase than that, and the people who saw me clearly, really saw me, they're the ones still at my kitchen table. That's enough. At 67, after everything, that is more than enough.